North Carolina is recognized.
Thank you, Mr. Chairman. I just want to say that I strongly oppose both this bill and H.R. 1109. I think they're both overbroad. They will have unintended consequences, though part of me thinks that they are intended consequences. These bills are not about transparency or national security. They're about making it harder for workers, consumers, patients, and survivors to hold rich and powerful entities accountable in court. They were written to give corporate defendants a new strategic weapon, insight into the financial resources of the people suing them, so that they can drag out litigation and force families to give up or settle for pennies on the dollar. In North Carolina, when families are poisoned by PFAS in their drinking water, or when a defective product harms a child, or when a worker is injured by corporate negligence, they should not lose their day in court because Congress decided to tip the scales even further toward the defendant. These two bills force disclosure of third-party litigation funding to corporate defendants, not just the judge. This is a crucial distinction. Today, judges already have the authority to review litigation funding arrangements to make sure that they are fair, ethical, and lawful, without handing a corporation a roadmap to the plaintiff's financing. The plaintiff doesn't get that roadmap to the corporation's financing. These bills add nothing to judicial oversight. They just hand sensitive information over to a powerful party. Third-party litigation financing is often the only way that an ordinary worker or consumer can bring a complex case. Cases involving toxic pollution, defective products, corporate fraud, widespread discrimination. It routinely requires millions of dollars in upfront costs for experts, discovery, and years of litigation. And these cases have become even more difficult to bring because the courts have made it more difficult to have class actions and nationwide injunctions, therefore making each and every litigant responsible for their attorney's fees. In North Carolina, we've seen communities along the Cape Fear River and other rivers forced to fight back against PFAS contamination. Rural communities taking on powerful agricultural and industrial polluters, and these families do not have corporate legal budgets. They rely on lawyers, who in turn rely on financing to stand toe-to-toe with the defendants. By choking off litigation financing, these bills would make it harder for families and injured parties to be able to challenge wage theft, unsafe products, nursing home abuse, toxic pollution, and so much more. And once the large corporate defendant knows the plaintiff's financial runway, they can strategically delay a case, engage in abusive discovery tactics, and drive up the costs. Even knowing that a plaintiff doesn't have a funding agreement can be weaponized, signaling to a corporate defendant that they can stall until the worker or survivor runs out of money. And to this bill's point, the claims about foreign interference in our justice system simply don't bear out. If we were generally interested in foreign sovereign wealth funds influencing U.S. litigation, the logical solution would be to carefully target disclosures to just address national security interests, not forcing a sexual assault survivor or a worker with wage theft claims to open their financing arrangements to the corporations they're suing. For all of these reasons, I'm strongly opposed to this bill and the other bill that we're supposed to hear, and urge my colleagues to stand with everyday Americans and not powerful entities seeking to evade justice. And I yield back.
Gentlelady yields back. The gentleman from Arizona is recognized.
Thank you, Mr. Chairman. I'm intrigued by the conflation of this bill with the ISA bill, which I think are actually very different things. This bill is dealing with foreign intervention in American litigation. And if we don't put something on this, we're going to continue to see a whole host of perverse incentives to come in. The argument so far has been, well, you have this defendant who's funded by a third party who's going to come out and just basically stall and drive the plaintiff into bankruptcy. This bill also prevents plaintiffs. So let me give you an example. This isn't hypothetical. This is in 2024. Sanctioned Russian billionaires created an investment fund to back bankruptcy lawsuits in New York, allowing oligarchs to steer tens of millions of dollars into Western financial institutions when they'd been sanctioned. They used that litigation to get around the sanction. Another instance, these are all reported in Newsweek, by the way. China-based technology firm Purple Vine financed several intellectual property lawsuits against Samsung that would not have been discovered except a lone judge who was watching over the case, who had jurisdiction over the case, happens to choose to require litigation financing disclosure in his courtroom. If that hadn't crossed the desk, the defendants never would have known that their case was hardly a mere legal challenge, but in actuality a case of national security importance. That's what this bill is designed to protect against. You can go on. Another case that was reported, getting around FARA filings. An Australian mining billionaire was paying legal bills for a coalition of environmental nonprofits in their lawsuit against ExxonMobil. It was only through looking at FARA disclosures that anybody found out that it was a third party from a foreign entity inciting litigation in our country. We're not even talking about the potential for frivolous claims that can be funded by a foreign entity. We're not talking necessarily even about the intellectual property that can be ripped off. So I think this is misplaced. How about this? Further analysis in the Newsweek, this one Newsweek article, and I'm going to submit it, and there's a whole host of other articles that I will probably submit. I don't want to weigh this down, but the hidden party industries, which this is called, is growing at a pace of about $17.5 billion in 2025, and by mid-2030s will grow in excess of $67 billion. And that's because they're pushing lawsuits that you otherwise wouldn't be bringing as being funded by foreign entities. So when you start talking about, oh, they're defending and protecting these big bad corporations, you're forgetting that there's also an incentive for plaintiffs to do the same. So that's, Mr. Chairman, I would introduce that Newsweek piece called "We Must Protect American Courtrooms from Foreign Interference."
Without objection.
And also, the U.S. Chamber of Commerce has brought this out, as they're calling it TBLF, particularly with regard to foreign entities. I would like to submit that. Theirs is, thank you.
Will gentleman,
The point is ultimately, I get your issues with the other bill. I may actually share some of those issues. This bill, I think, is a vastly different bill. I think it is more narrowly crafted, and I think it is designed better and it's clearer. But if you're going to argue unintended consequences, if this bill doesn't pass, you're going to see a continued growth in third-party foreign entities in our litigation for a whole host and myriad of reasons, not the least of which is theft of intellectual property, trying to get around our laws and sanctions, just like the Russian billionaires did in 2024. And with that, Mr. Chairman, I'll yield back.
Gentleman yields back. Gentleman from Maryland is recognized.
Mr. Chairman, thank you. And I appreciate the remarks of the preceding member. It seems to me that what happened in the case that you're describing is exactly what ought to have happened. That is, if the claim is made that the client of a particular lawyer is no longer or never was controlling the case, and that is a fake client and a proxy for someone else, then you make a report to the judge. You file a complaint and you say, hey, I don't think this is real litigation. I think it's being controlled by a third party. The third party may be paying for it or not. They might be domestic, they might be foreign.
The gentleman yield for a second?
Well, let me just complete the thought and I'll come right to you. And so, therefore, they went to the judge. They raised the point that there was an absentee third party who was actually controlling the litigation, and the judge had complete power to work it out, to demand disclosure, and so on and so forth. That could have happened with a domestic corporation. It could have happened with another domestic person. It could have happened with a foreign private corporation, foreign state, what have you. And we do want to prevent that because of the rules saying that you've got to follow your client's wishes and not that of some other third party. So I don't quite see what the problem is there. I mean, is there some general problem? Because what I want to raise is the real problem of money going directly to American public officials, including the President of the United States, directly from foreign states or indirectly from foreign states in their companies, and then putting in their pocket. I don't quite see what the issue is with, say, a foreign state who invests in a business, and that business makes loans to people, and a loan is taken out by a law firm to bring a case based on some cause of action, which a judge is going to consider, which a jury is going to consider, and I'm not quite sure exactly how that contaminates our legal process, but I'm happy to yield.
Yeah, thanks for yielding. I'm not sure that we're reading what transacted in the Purple Vine case the same way. That wasn't Chinese companies that necessarily invested in American companies as a front. What that was is they financed lawsuits against Samsung so they could get intellectual property as discovery. You see, that's really part of the issue that comes up here. And the other one is you're concerned you didn't address.
Well, if you would just pursue that for a second, okay, and that violates what law or what rule of ethics or rule of professional conduct? In other words, if, say, all these conservative groups that are writing in and say they get a donation from, some other source that's interested in their winning a case, what rule of professional responsibility does that violate?
Well, what I will tell you is if a Chinese Communist Party is funding going after U.S. intellectual property through litigation because we have this open system, maybe protection of our national security interest is important. How about you didn't?
I thought you were talking about compromising the integrity of the judicial process. In other words, that's just back to a bland abstraction, national security, and I'm not quite sure I see what it is. I mean, if we want to say the Chinese government, the Russian government, none of these governments can ever sue in American courts, fine. But if we're not saying that, if we're allowing them to sue, what's the problem with them contributing money to somebody else's suit and the judge having the opportunity to force disclosure?
Mr. Chairman.
And I'm happy to yield also, because it's an honest question.
Well, I appreciate the gentleman's question. Courts can't police what they can't see. And so what you have are the structure of third-party litigation funding often being made to conceal the true source through layers of intermediaries, and the judge, the court, doesn't recognize they don't have the information needed to protect the integrity of the proceedings. This would provide that disclosure and provide that information so the judge can make the choice and can make a better decision.
Okay, right. But this bill forces the disclosure to the corporate defendant, not to the court, as in the case we just discussed, right?
This bill targets only foreign states and sovereign wealth funds. It doesn't target private investors or domestic funders. It is designed to target foreign third-party litigation funding. So it's not just to one entity, it's to both.
Okay.
If the gentleman would just,
please.
Let me just ask this. If you believe that in the Purple Vine case that's exactly how it should have happened, how would the judge have known, but the judge was extraordinarily vigilant? Because it was not disclosed. The judge was looking at things that, there's something going on here, finds out, and if you're okay with the judge finding out and saying, wait, we got a problem here, then why not codify that process in law, which is what this bill does?
Okay, thanks. I think my time is up.
Sorry.
The gentlelady